you. Just before the break,
yes,
we were having a discussion about the review provisions. Can I just say two things? The first is that when I was launched into an explanation about automatic barring, that was actually not entirely right. So could you scrap that? That was just before the adjournment, and I apologise for getting that wrong. At least I read my sister's slightly panicked look correctly when I said I'll check that over lunch. So I apologise for that. But what we've provided on your desk is paragraph 18, paragraph 18A of Schedule 3, and the Safeguarding Vulnerable Groups Act, barring procedure regulations 2008.
Yes.
And copies have been left for Milena Friends as well. So paragraph, we'll just talk through those quite quickly. Paragraph 18 is the provision that my Lady Justice Laing was referring to, which is a person may apply for a review of his inclusion, and there is, and it may only be made with permission, that's subsection 2, and then at subsection 3, a person may apply for permission only if, and then there are criteria. The application is made at the end of the minimum barred period. So the minimum barred period depends on the age of the individual, but in broad terms, if they're under 18, it's 1 year. If they're under 25, it's 5 years, and if they're over 25, it's 10 years. So that explains the statement in the letter at page 105 of the core bundle. But I wasn't in fact wrong either when I said that reviews could happen at any point, because there is a power under paragraph 18A, which is the next page of your clip, which enables the DBS to undertake a review, subparagraph 2, at any time of the person's inclusion on the list. And any such review, subparagraph 3, DBS may remove that person from the list if and only if it is satisfied in light of A, information which did not have at the time of the person's inclusion on the list, B, any change of circumstances relating to the person concerned, or C, any error by the DBS, it is not appropriate for the person to be included in the list.
So that tends to put the onus on the DBS. So what that means is that the DBS might say that in the light of the fact that the teacher's TRA acquitted him, it could come to the conclusion that on the basis of the information that it now has, it wouldn't be appropriate, but he wouldn't be able to ask them to do that.
You're absolutely right that they can review on that basis, and indeed I understand that if something along those lines happens, they tend to. It's an internal process. But I've specifically taken instructions on the questions of, well, can an individual just nonetheless say, could you please review the case under paragraph 18A? And they can ask the DBS to do it, and the DBS will respond, and that decision would be subject to judicial review if it was irrational.
So there's nothing stopping it being raised, at least.
Exactly.
It's not a formal application.
Correct, that's right.
Yeah.
So in other words, the person concerned can ask the DBS to exercise its power under 18A.
Yes.
Right.
And that's not a formal application for a review. He's just saying,
no, it isn't.
Please exercise its power.
And in some ways, in practical terms, that's actually a very useful situation, because very often the regulators and the DBS do not necessarily know exactly what stage each other is at.
And also
the individual will know, but the DBS doesn't get automatically sent.
The circumstances in which the DBS can review its own motion are wider.
Yes.
18A3 than the circumstances in which they can review on the application of the person who's being barred.
Yes.
And inevitably, in that type of situation, it would have information we didn't have at the time.
Yes.
Right. Yeah.
Okay. Well, that's really helpful.
And the final part of that clip is the regulations 2008, and the only reason you've got those is just to show you what the minimum barred periods are, which I think is set out in regulation 9 in this case, and that sets out the 1 year, 5 year, 10 years, depending on the age of the individual. So I hope that sort of wraps up that point.
Yes, thank you. That's really helpful.
No, very helpful.
Going back to my lady Justice Andrews' question about the High Court and what is the position, is the High Court decision binding? And the example that was given was if, for example, it found that the TRA's reasoning was completely irrational and the DBS had effectively accepted the same reasoning because they just plucked the adverse findings and put them into their letter. The answer to that is that the High Court is obviously binding for what it decides.
Yes.
And it's hard to see how where the reasoning is immediately transferable into what the DBS did. It's hard to see how the DBS could then defend that, because inevitably the Upper Tribunal would say, well, it's irrational for exactly the same reasons that the High Court found it was irrational. But all the time, the reason it's not an immediate and automatic outcome one way or another is because you've got to remember the Upper Tribunal is always looking at this matter through its own lens,
Yes.
the lens of its own statutory appeal scheme and procedurals, and the evidence that it has, etc. So I hope that answers what we say is our position in relation to that. Could I then just briefly, and I said I would come back to it, is ask you to just pick up tab 5 again of the authorities bundle, please, which is back into Schedule 3, but this is paragraph 6, which is on page 12 of the authorities bundle.
Yes.
And the point about showing you this provision is that we say it demonstrates that in certain circumstances, Parliament has regulated what should happen if a different body is already looking at something. And this applies in relation to Scotland, so obviously it's not relevant here, but the point about paragraph 6 is that it provides that the DBS must not include a person in the children's barred list, only on a particular ground if a relevant Scottish authority has already considered whether the person should be included in a corresponding list on the same ground, whether or not it decided to include him on the list, and then B, some other reason. But the point about that is it sets it up in contrast to the position in paragraph 16, and is another reason why, if Parliament had intended to say that that paragraph 16 effectively meant that all findings by a competent body were binding or automatically binding on the DBS, it would have said so in terms. So, and see, for example, paragraph 6, which is not exactly that, but it does demonstrate that the act.
Is this again at the DBS level, if you like?
It is.
Yeah. Yes, I see.
But there would never be an appeal in those circumstances because it's the DBS must not include a person.
I can see the complete force of that argument at that level. That Parliament has specifically turned its mind to potential conflict between a finding by the Scottish authority and the potential for a finding by the English authority, and has said, this is how you deal with that position.
Yes.
And they've also specifically considered how to shepherd the disgruntled teacher into the appropriate channel for appeal in cases where they haven't yet had a decision from the DBS. That I completely get.
Or nurses, or
nurses,
any
or
other people that are
exactly, or whoever it may be. Yeah, whoever it may be. Parliament says, right, this is what you do. You don't argue the same point twice in front of separate bodies. You go down this particular route rather than that one. You simply can't argue that it's wrong. That doesn't mean to say that you can't argue that it's wrong in front of the Upper Tribunal at that stage, because matters may have moved on,
yes.
And you accept that.
Yes.
So none of that really helps, does it, in telling us what the position is as between where you've got a conflict between the two decisions.
Well, what all these submissions I hope do is demonstrate that the ground one that has been
Yes.
made is wrong. the ground one.
Yes,
the
you say that insofar as ground one depends upon the language of the statute, it doesn't get the appellant anywhere.
Yes.
Yes, all right.
And then can I just very briefly turn to the question of weight?
Yes.
So the focus of the oral submissions, notwithstanding that doesn't really appear in the skeleton, was on the question of weight, and in particular, just find my notes, please. Paragraph 67 and paragraph 128. These were the paragraphs that particular emphasis was placed on, and they are at
Page 72.
in the core bundle.
Page 72.
Thank you, Neil. Yes, so page 72, paragraph 67, and the criticism was, well, it doesn't say how much weight is appropriate, but I'm not sure where we ended up on the oral submissions as to whether it was accepted that was correct statement of principle or not. But in addition, what was missed out was page 76 and paragraph 89. So that paragraph provides that since the date of the barring decision, further evidence in relation to allegations become available, we are entitled to consider that evidence to decide whether, notwithstanding that the fines in the DBS were open to them on the evidence before them, any of those fines were mistaken. That includes the trial decision, so they're clearly taking that into account, although that's clear from the rest of their determination in the event. And then paragraph 128.
But just before we get to that,
Yes.
What was the further evidence? Was it the decision?
It says it includes the decision, but what else was there?
Well, there will be XYZ oral evidence, which obviously under cross-examination is not going to be identical to what the
Because
TRA
at the level at the DBS stage, he'd given a no comment interview, I think. Is that right?
Exactly.
So there's a whole lot of new evidence.
Yes. So at the level of the DBS stage, the position was
Oh, I
in
see.
written
Sorry.
submission,
the evidence that was
entirely
sorry, quite
refuted
right. Yeah.
all the allegations, including
No,
that
quite
he
right.
picked her up
Quite right. Sorry,
in
yeah,
the car.
I understand.
So
So I was looking at the wrong decision.
So the further evidence that was before the TRA.
Yeah.
and then page 82 paragraph 128 is again consistent with the approach that the Upper Tribunal was taking, which we say is right. But what I would like to say is this. It's quite clear from the second sentence in paragraph 128 that they were giving the TRA decision serious consideration and weight, because they didn't say we're going to ignore it, we're just going to proceed on our own basis. They started off by saying is the question we need to ask ourselves is not whether the TRA were entitled to come to the findings it reached on the evidence report, but rather whether anything in the TRA decision demonstrating that the barring decision based on a finding fact was mistaken or wrong. So their starting point is obviously to say, well, clearly it's going to carry weight
I
with
think it
us.
was accepted that may have been correct. That approach.
So that is accepted as correct.
Well, I'm not-
I mean, my submission
noted
is that is an indication that the Upper Tribunal was in fact according it serious weight, because it's saying, right, well, you know.
Well, this is all on the assumption that grounds 2 and 3 don't fly, and they're not bound by the fact findings.
Yes.
Yes.
Yes. Of
So
course.
on that assumption, you say, well, the question of appropriate weight is acknowledged, and then the question we need to ask ourselves is not whether it was entitled to come to the findings it reached, but whether there's anything in it that shows that the barring decision was wrong.
No, that the TRA decision was wrong.
No.
No.
Anything in the TRAI decision demonstrates
did.
the barring decision was based on a finding of
Yeah,
fact that
sorry,
was mistaken
yes.
or wrong.
Yes, quite right, yes.
Now, you see, if we just pause there for a moment and assume that that's a correct finding in terms of a correct approach
Yes.
in terms of the law, you would actually stand back and say, well, the TRA decision found that these findings were not proved,
Yes.
and that in fact he hadn't engaged in any conduct that was inappropriate for a teacher. But they then go off and make their own findings of fact.
They do, but their starting point is the TRA's.
Well, is this point you make that in fact, to unless they're going to just dismiss it, they have to find a material error of fact in the DBS, and after that they're then entitled to make their own findings of fact on whatever evidence they've got.
Well, that's true insofar as the approach of the upper tribunal looking at the DBS decision is concerned.
That's what I mean.
But
yeah.
insofar as what respect does the upper tribunal have to accord the TRA decision, it's a different exercise, and it's clear that what they did in that case is they've specifically given reasons and expressed concerns about the TRA decision.
They've engaged in a critique of it. They have engaged in a critique of that decision, and that is not their function. Their function is to decide whether or not the findings made in the TRA decision demonstrate that there was something wrong with the barring decision. And where they're at complete odds with one another, why isn't there something wrong with the barring decision?
Because it's not a material error of fact if, whatever the TRA might have found, if they find facts that are consistent with the DBS decision and uphold it on that basis.
Well, in that case, you might as well not have a TRA decision at all. What weight are you affording it if you just say, well, we don't like this decision, we'll make the decision ourselves on the same material?
But they haven't quite done that, have they? They've looked carefully at the TRA decision and decided that there were problems with it.
Correct.
I mean, that is, I'll put my cards on the table, Miss Broadfoot. That's the part of this appeal that concerns me the most. You may well be right that they're not technically bound by it, but they are effectively taking upon themselves the role of an appellate tribunal from the TRA panel in what they're doing. And they're saying we're going to subject this decision to a whole lot of scrutiny to find out whether or not it was justified. We've come up with a completely different decision on exactly the same evidence, and we're going to substitute our view for theirs. And that's why the appellant is aggrieved. Now, he may not be right to be aggrieved, but that's the concern that I have.
I hear that, of course, but that is the system that
You say they're entitled
parallel
to.
proceedings is the system that's been set up
Also,
by Parliament.
it is possible to make the point that the Upper Tribunal is a court and is treated by the 2007 Act in many respects as the equivalent standing to the High Court, whereas the TRA isn't a court at all.
And it's a court. Well, certainly a quasi judicial body.
But it's not a court. It's not a court.
No.
So can I just ask this question? Are you, just so I can understand for myself, you say that they've asked themselves the right question in that second sentence of paragraph 1 to 8.
Yes.
And have they then actually found that because of the TRA that the DBS at the lower level was mistaken, but then have gone on, as it were, to be able to reassess the situation? Is that what they've done?
I don't think that's what they've done.
No, they've said...
Because they're not entitled to do that, are they? Because if you go to tab 3, unless tab 3 of the authorities, I think it is, bundle, and section 4 appeals. If you go down to 6, it says if the Upper Tribunal finds that DBS has made such a mistake, it must direct the person to be removed or remit the matter. And at 5, unless the tribunal finds it's made a mistake of law or fact, it must confirm the decision.
Yes, so it's been...
So it's very, those are its only powers, isn't it?
That's right. It's been long established, though, that it's got to be a material
Yeah,
mistake.
sure, yeah.
And indeed, in the letter, you might recall that there was a reference in the letter to there having been he hadn't challenged the minded to bar the assertions by the DBS, and that was found to be by the Upper Tribunal a mistake, but it wasn't material because it was just, I think, perhaps a sentence that had crept in by mistake. Whereas if you looked at the whole process, it was clear they had engaged with those submissions.
So in fact, what they've done is they've reviewed the evidence.
Yes.
Yes, the TRA. They've looked at other evidence, as they would say it themselves, and they've come to, as it were, the same conclusion as the DBA came to in the first place. In other words, that they hadn't made a mistake of fact, etc.
That's right. I mean, their function is to look at all the evidence before them and to decide whether or not there's been a mistake of fact or law. But the evidence before them will include the findings of the TRA.
Obviously,
but that's all. That's all it is. And obviously, if there's compelling reasons, or there might have been something in the TRA evidence that you couldn't explain away. Let's say that the complainant had come and she'd withdrawn her statement, said no, it's true, it never happened. Then it would be very difficult in those circumstances. Potentially for the Upper Tribunal, they would take into account that evidence as well and say, well, the DBS.
But you're saying that they're entitled to reach a view and a different view from the TRA.
Yes.
Well, yes. I mean, if what they said they were doing was, we're entitled to look at everything that's before us, including the TRA decision, and for the purposes of asking ourselves whether the barring decision was mistaken.
Yes.
That's one thing. That's not the exercise that they say they're conducting. The exercise they say they're conducting is to look at the TRA decision and see if there's anything in that decision which demonstrates that the decision, the barring decision, was wrong. And that's a different exercise, with the greatest respect. They're looking at whether the TRA decision can stand with the barring decision. Whether the one casts any light on the rightness or wrongness of the other. And if that is the exercise they're genuinely going through, then it's a different exercise.
With respect, I think that might be applying this sentence to a level of...
I'm just taking it at face value as to what they say they're doing, because then they start examining the TRA decision and assessing... on one view, it could be said, well, they're just looking at the weight that they should afford to it. But
that may partly be a consequence of the way the submissions were made, or
yes,
also
because presumably that XYZ was relying on the TRA decision as showing that the DBS's decision
and there'd been
was
a
wrong,
specific application
to
admit it,
which is why they're dealing with that. That's the submission they're answering.
And if you go on looking further down, but not very far down, at paragraph 131, they're dealing squarely with the evidence that they heard from XYZ. And they're weaving in the findings as they go of the TRA.
I mean, if you take it literally, what they said 128, in some ways, there was something in the TRA decision which looked like a mistake, didn't it? Because of the finding, for example, that the kissing didn't take place.
But only if
they
accepted, they were bound by those findings.
Yes. And they say they're not.
No.
Exactly.
Yep.
And the point is that it's a very basic public law principle. If you've been given a power by Parliament, you can't delegate that function to somebody else.
Exactly.
So if the Upper Tribunal can't delegate its function of deciding whether or not the DBS decision is wrong by simply rubber stamping what the TRA have decided.
Well, absolutely not. But on the other hand, it's not its function to act as an appeal body from the TRA. And there's a great deal of 129 and 130 that has the resonance of that type of approach.
I hear what your ladyship is saying, but I think with submission, with respect, I think that's a bit unfair. In circumstances where the appellant was saying, look, these are all the findings that have been made, they heard this evidence, they heard that evidence, you've got this evidence, you're bound by it, it's inevitable that they need to engage in some detail with the TRA decision. I mean, it's not a finding that the TRA decision is unsustainable, or it shouldn't be, or it's not an appeal from the TRA decision. It stands as it is. And yeah, I won't repeat myself.
Anyway, you say that they're engaging in the proper function that they're entrusted with, which is looking at the implications of the TRA decision, amongst other things, for the DBS barring decision, because ultimately their focus has to be on whether or not the findings of fact were mistaken.
Yes, that's right. So that's all I wanted to say about ground one. Sorry, one last thing very quickly about ground one. Can I just say that the fact that there may be parallel proceedings is also recognised in the TRA's own internal documentation. So if you go to the back of the authorities bundle at tab 28, on page 375, paragraph 5.
Tab 28.
So
Yes.
page.
375.
Thank you. Yep.
Paragraph 5.
Well, that's helpful to you, isn't it?
It is, because it indicates not least that the two bodies recognise, or certainly the TRA recognises, that there can be parallel proceedings.
Yeah. And different decisions.
And different, in different criteria. I mean, perhaps given we've got that open, I could just show you that although obviously in this case there was quite a strong overlap between the type of behaviour that was relevant for the TRA and the DBS. There's no denying that. If you look at further in the same document, page 378,
Yeah.
at paragraph 21, 21A, there's an explanation of what is unacceptable professional conduct. I think you may have already been shown this bit. Misconduct outside the education setting will amount to unacceptable professional conduct only if it affects the way a person fulfills their teaching role or may lead to people being exposed. If you go over the page at paragraphs 23 and 24, then there is reference to offence of the types listed on page 12, which if you look at that list is on page 381 and 382. Now obviously some of the matters on page 381 and 382 would obviously be of interest to the DBS as well, but not all of it. So for example, possession on page 382, the 6th bullet point, possession with intent to supply another person or...
Sorry, where are you on? Oh, I see.
Page 382.
Yep.
So possession of any Class B or Class C drugs, for example. So that may not be of interest, may not be a matter on which the DBS would list somebody on the barring. It may not, but it would be relevant to the TRA. So my point is that there's a very broad range of matters that could, for example, bring the profession into disrepute, which is another one of the TRA's functions of considering. That's on page 379, and it's not necessarily the case that, well, in fact, they don't have the same jurisdiction or interest at all.
Yeah, no, I mean that is all very helpful. We are dealing with a particular set of facts, of course, in this case,
Yeah, of course.
which it is basically the same matter.
It is.
That was being honed in.
But we're also here dealing with questions of principle.
Well, no, I entirely
and
accept that. Yeah.
Okay. So, right, could I then very relatively briefly deal with the question of privies, which is ground 4, before I then turn to grounds 2 and 3. And the reason to go to ground 4 at first is because if the parties had privity of interest, then the consequences, certainly if this cause of action is stoppable, well, it's automatic. My submission is...
You've got to have a cause of action to start with. And at the moment, I can't begin to understand where you get with cause of action is stoppable.
That's absolutely right, my lady.
And I asked Ms McLaughlin to explain what the cause of action was, and I never got an answer, really.
No.
No disrespect to Ms McLaughlin, but she kept saying it was the facts, and the facts are not a cause of action.
No.
I mean, what we're dealing with here are two statutory bodies with regulatory functions that overlap but are not identical.
Yes.
And their process is, to an extent, investigatory rather than adversarial, although there's adversarial elements to it. If the complainant is, let's say, the school or the pupil even, in one of these, they don't have status, but it's not the same as adversarial civil litigation at all.
No.
It's not the same as a trustee and a beneficiary being bound by the answer to a point on a trust, for example.
That's absolutely right, and but the two bodies are also significantly different, just in terms of the way the outcomes are dealt with. So, where under the TRA, which involves effectively a disciplinary procedure, a teacher is made subject to a prohibition order. That prohibition order is published with his name.
Yes.
And also a summary of the reasons for it. And that's all set out, the legislative basis for that is set out in our skeleton.
Yes.
By contrast, the DBS process is one that is, the DBS list is never published, and indeed even a victim of someone
Can't get hold of it.
Yes.
can't get hold of it and can't be told what the outcome was, and that's the case of SXM, which is again cited in our skeleton argument. And the section that we cite in our skeleton argument, which explains it's not a prosecutorial, it's a different type of proceeding. It's not meant to be punitive, although it will feel that way, is by its very nature different from a disciplinary proceeding before a regulator, even though ultimately both proceedings may have as part of their function, well, certainly the DBS is in their entirety their function, the protection of the public. But the TRA has also got as its function not just protection of children, but also the protection of the reputation of the teaching profession, and otherwise you wouldn't have.
Yes, there's an overlap, but it's not identical.
No. So I mean, we say that there's no cause of action, a stop point at all, which deals with ground 4. We've got a list of reasons why, in any event, they're not privies, but it may be that some of those reasons are best fed into grounds 2 and 3, to which I'll perhaps now turn, unless you want to ask me anything else about that.
So your basic point is there's no cause of action here?
No cause of action.
Okay.
The cause of action stoppable is completely the wrong.
That reasoning would apply equally, I would have said, to the primary basis for Mr. Justice Mostyn's decision that was prayed in aid.
I was going to turn to that because, of course, I heard you raise in before lunch. Well, do you say Mr. Justice Mostyn's decision was correct or not? It's very difficult to see what the cause of action was in that case. But can I also point out 2 particular features of that case, which we say are highly relevant. The first is that set out at paragraph 2 and repeated elsewhere in the judgment, including at the end.
Sorry, tab.
Apologies. Tab 18,
Thank you. Yep.
page 96.
Yep.
Yes.
There's paragraph 2. 2 separate bodies regulating the same field, historical accident, the set of practitioners governed by the defendant interested party are not intersecting but congruent. That's obviously not the case here. They are one and the same. Similarly, the 2 sister bodies stipulate common ethical standards for their members. It's unthinkable that they should differ. Those standards may be expressed in different language by the two bodies, but they are nonetheless the same. Of that there can be no doubt. And then there is similar statement. I think it's at the end of the judgment, which is on page 105, just above paragraph 48. Where the complaint to each body was identical and the bodies are performing precisely the same functions over the same professions in accordance with the common ethical standards. So that makes it unusual, first of all. The second point that was unusual is that the second body in this case agreed to recognise the judgment of the first one. So there's a wholly separate argument that runs through Mandic Bozic, which was because in that case the individual sought to stop the second body from running parallel proceedings at the same time or around the same time as she was dealing with the proceedings in front of the first regulatory body. And she brought judicial review proceedings, and there was a consent order in which it was agreed. That's page 103, paragraph 33. Sorry, no, that's not right. Give me 1 moment. 32, paragraph 32. Consent order was made which prevented the defendant from taking any steps in the complaint to it.
They recognise any position.
It recognised. And then there's a discussion at 34 about what does recognise
mean, yes.
And he found, in effect, that it has a legal meaning, which means agree to be bound by. And at 35, paragraph 35, the judge says, in my judgment, when the defendant agreed in the consent order to recognise the decision of the interested party, it must be taken to have chosen the word carefully. It must be taken to have accepted that the decision would be valid and binding against it. So that's the second significant point of difference, and may well explain the reason that Mr. Justice Mostyn came to his alternative conclusion, having decided, with respect probably wrongly, that there was a course of action stoppable, that if he was wrong about that, and that's paragraph 45, then he finds under the collateral attack doctrine it would be manifestly unfair, etc.
Well, one wonders if that's the correct, I'm not saying you're wrong, but if that's the correct analysis, one wonders why it's not straightforward estoppel by representation on the basis there's a solemn promise embodied in a consent order of the court that if body A acquits you, will acquit you too. And then they renege on that.
It's just a very short point.
It's a very short point, isn't it? And it's pretty devastating. But
you might have thought, but the statement is there. It's a
yes.
It seems like there may have been people
but
may have gone.
Mr. Justice Mostyn obviously thought that wasn't necessarily a short answer to the point. No. Anyway, we're not bound by Mr. Justice Mostyn.
You're not. Of that, we're all agreed.
Yes.
Yes, so that
but
was,
one can see why he thought it was jolly unfair in the light of what you just pointed out to us.
Exactly.
Yes.
Exactly.
Yeah. When Body 2 actually goes to the trouble of embodying in a consent order a solemn promise that they will recognise what was said by Body 1, then to go against that is not exactly fair and equitable.
Yes. All right, then the abusive process doctrine. I'm not going to go through every part of my skeleton, but our starting point is we say that the Hunter doctrine does not apply here at all.
Yeah.
If you look in the authorities bundle at page 301, paragraph 44, So this is, apologies, I should introduce the case better. This, of course, is the recent Supreme Court decision in Muin Udin, the
Yes.
State for the Home Department. It was issued.
Is that the
last
case
year.
that looked at Johnson and Gore Wood?
Yes, it looked.
Yes.
It looked at. It was a case about criminal proceedings abroad, and the question was whether it was an abuse process to bring criminal proceedings
Here.
Yeah.
here. And so there was a lot of discussion of what is the scope of the doctrine of abusive process and the Hunter doctrine in particular. And the analysis starts at page 299 at the bottom, abusive process, and you'll see at paragraph 39, which is highlighted, two aspects of Lord Diplock's statement should be noted. First, the power in question is the power to prevent misuse of the court's procedure. Follows that the power cannot be exercised if the claimant is making proper use of civil jurisdiction to protect his rights. Secondly, the court's procedure must be misused in a way which would be manifestly unfair to one or more of the parties, or would otherwise bring the administration of justice into disrepute.
Do you say that does not translate across to regulatory bodies, or do you accept that at least in principle it could?
In principle it could,
Yes.
but if you look at paragraph 44, it looks like it requires the initiation of proceedings in a court of justice for the purpose of mounting a collateral attack.
Well, that's certainly true of Hunter.
Well, that absolutely, and it seems to be true of a lot of the cases in which these matters are considered.
This was a case in which there'd been a criminal trial, but he hadn't been present, and he then brought a libel claim.
That's right.
So, I mean,
That's right.
on the face of it, similar to Hunter, but he wasn't present at the criminal trial and had an opportunity to contest the charge.
Exactly.
So Hunter doesn't apply, in short.
Yeah.
And exactly, and didn't. And you'll see that at paragraph 3, at page 306, that part of the reasoning and the explanation in relation to Hunter at 62, paragraph 62, if proceedings are to be characterised as an abusive process, the claimant should have what Lord Diplock described in Hunter, a full opportunity of contesting the decision in the previous proceedings in the court by which it was made. Now, of course, in that case, he didn't, for a whole variety of reasons. But if one pauses there, this is where the two bodies being different is important. The DBS has no standing in the TRA proceedings. It's not a party to those proceedings. It doesn't get involved in them. Indeed, it might look peculiar if it actually sought to, because it's got its regulatory functions.
I suppose if you go back to paragraph 39, you'd say, assume that on the two questions it has to look at, the power is to prevent misuse of the court's procedure. It follows that the power cannot be exercised if making proper use of the civil jurisdiction. And you're saying it was making proper use of the Upper Tribunal and the DBS situation here, was making proper use of its powers.
Well, certainly the appellant in appealing was making proper use of the tribunal's powers, perfectly entitled to appeal. And of course, that's the other oddity about all of this. It's not the DBS that's bringing proceedings against the individual.
But it's a party, obviously.
The individual is availing himself of both the opportunity to challenge the DBS and to pray in aid the decision in his favour made by the teachers' authority.
Yes. And going on, staying on paragraph 39, the court's procedure must be misused in a way which would be manifestly unfair to one or more of the parties. But it's the court procedure that's being brought.
So it's a question of, you say it turns on misuse, as is explained in paragraph 65. Diplock's description of abusive processes of the misuse of the court's procedure in a way which would be manifestly unfair or bring the administration of justice into disrepute. You say, well, nobody's actually misusing the court procedure here.
Yes.
And it's a misuse that consists of bringing proceedings.
Yes. Which is why it's not because the DBS didn't bring the proceedings, it's not their misuse.
No.
And they are entitled to defend those proceedings. So then there's a question of whether there's a sort of freestanding aspect in relation to, unfairness. I mean, the court's procedure must be being misused in a way which would be manifestly unfair or would otherwise bring the Minister's justice into disrepute. Reasons all set out, obviously, in the skeleton. Obviously, one, it's not a misuse, but B, the systems are set up the way they are by statute for a specific reason, and the two bodies have different, albeit overlapping, functions. They're regulated by different statutory provisions.
That's see where that takes us, but suppose I'm just testing this proposition to its limits for a moment. It's not this case, but suppose that the Upper Tribunal were to say, well, we see what the TRA has said. TRA has had the advantage of seeing and hearing all the witnesses. Let's suppose a different situation where nobody gives evidence before the Upper Tribunal at all. So you're just left with what was before the TRA. The DBS didn't have the benefit of any of that. We think, to use the vernacular, the TRA was being unduly generous to this particular individual, and although we've not had a chance to hear and see him, we think it's blindingly obvious that he's been doing something really dodgy, and therefore we'll ignore it, give it no weight. That's a matter for us, and we will uphold the decision of the DBS. Now, that kind of scenario, would there be anything that the aggrieved party could do about that?
They might make an argument that the decision was irrational, I suppose.
Yes.
But as a matter of principle, the approach must be the same.
Yeah, that's what bothers me. It really does. So, if you take it to extremes, provided that they pay lip service to what the TRA has done and take it into account, they're absolutely free to ignore it and substitute their own findings.
Well, remember that I've not accepted, and certainly not my submission, that they are free to provide lip service, that all they need to do.
No, but I mean, that's the natural consequence. I'm not saying that's what happened. I am not saying that's what happened here at all. I make it very clear that I'm not saying that that's what happened here.
You're not saying what happened, but equally, I mean,
you say, no, within the bounds of reasonableness and rationality, and obviously there'll always be JR challenges if the UT goes completely overboard. Yeah.
But presumably, what you do say is that provided it's a rational decision, perhaps the TRA may have made a rational decision on the facts as one to which they were entitled to come, and on the same facts, the Upper Tribunal has made a rational decision on the facts.
Yes.
Where you'd come unstuck as if they were to make an irrational decision. And then that would be open to challenge on
as an error.
You say it's a classic example of a situation in which a decision maker faced with the evidence has a range of decisions open to it, and classic example is where this court might not have reached the same decision as the underlying body, but it's open to it, and therefore we don't interfere. And again here, once you postulate that there's a range of decisions that are reasonably available and there's no overlap between the functions, you say, well, if you're not bound as a matter of statute by the findings,
Yes.
then the weight you afford to it is up to you, and provided you go about it in the right way, that's the end of that.
Yes, and that's no different. I mean, that exists
Yes.
in administrative decision making all the time.
Yes.
And if there's any unfairness that's perceived, obviously by the aggrieved party, can be put right if it's possible to do so on challenge to the second decision.
On the point of law.
You mean the
Yeah.
regulatory body's decision? Or
No,
the
on
upper
yes,
tribunal?
on the
tribunal's
upper
decision,
tribunals,
yes.
if they can. I mean, obviously,
Yes.
Yeah, so it's an appeal on a point of law to set them right.
Yes.
But,
Yeah.
but to go back to my lady's point, if it's the kind of decision where reasonable decision makers could reach different decisions on the same material, then each decision maker acting lawfully could well reach a different decision.
Yes.
And you would say, in this particular case, the Upper Tribunal has looked very carefully at the underlying material. It's given cogent reasons for its disagreement with the TRA, and as a result of what it's looking at, it says, well, we've reached a different conclusion. Of course, unlike the TRA, we've had the advantage of being able to evaluate for ourselves its evidence.
Yes.
Not a case where they've got the advantage over us in that regard, because we've seen and heard him too.
Yes.
All of those points.
And there, of course, they may well have found much more persuasive the reason why the girl in question, well, pupil A, didn't tell the police the first time, and then gave her account subsequently to the police.
Well, that's not the other side's best point. I mean, you get inconsistencies. I mean,
exactly.
It would be more worrying if it was the other way round in a funny sort of way.
Can you just, on that point, can you just remind me, did the Upper Tribunal deal specifically with that point? I think Mr. Dingley was submitting that they hadn't. And I have a feeling
I thought
I thought they had.
Yeah.
But I couldn't put my finger on it when I was looking
Is this
this
the Upper
morning.
Tribunal or the
The Upper
DBS?
Tribunal, yeah. It may be that I've misremembered. I mean, it's not a terribly important point. They touch on it in paragraph 133, but only just sort of touch on it and then move on to, there's been a turnaround in
Yes.
XYZ's evidence. I have a feeling I've read somewhere that that did deal with it. I mean, it's not.
I can't immediately find it, but there's quite a lot of this decision.
Yes, it is quite long.
Well, it's sort of raised, but not only to give an account of what happened at 93, isn't it? But obviously
Well, that's
just
where the panels dealt with it.
yeah, exactly. That's not. There's nothing they say about it there.
Yes. Well, those behind me no doubt will look for it, and no doubt Mr. Dingley will come back on that point if he wants to. Could I just say then, having made these submissions so far, could I just deal with the standard of proof point, which seems to have created sort of side issue of its own? That's dealt with by the Upper Tribunal at paragraph. Sorry, let me just find it.
I think that's a misreading actually of the TRA's decision. It's paragraph 130.
Yes.
Speaking for myself entirely, the part of the paragraph beginning, we are also concerned that the TRA panel's explanation that could provide indisputable evidence. I think all that the TRA panel was saying is, if we'd had the phone messages, or if we'd had the phones, we wouldn't be in a position where we had to look for other evidence around it, because it would be indisputable. You actually have the hard evidence, and there it would be, and you couldn't really go behind it. But because we haven't got that evidence, that nobody could challenge about whether the messages were exchanged, we have to look to see what the probabilities are about them being exchanged, and there isn't really much else in the way of evidence that helps us.
That's definitely one. That's one reading, but actually you'll see from our skeleton at paragraph 49.
Yes.
Which is an internal page number 19.
Yes.
Supplied a replacement with all the references in. That there are a number of indicators that might, and even then on its own you might think not very convincing, but as I realised last night, in fact the submissions that were made to the Upper Tribunal actually take that wrong approach.
Right.
And although we don't have the submissions that were made by the same legal team to the TRA, it's page 107 of the core bundle.
Right. And one can't really make the excuse that this was all before before the law was clarified, because these submissions post-date that. But
also, if one looks at Jones, they say very clearly the law has been clear for some time now, and they just restate it. I just picked Jones as a recent example.
Yes.
So it's paragraph 19.
Namely the more serious the allegations.
Exactly. And that's expressly disproved in Jones by the thrust of all that case, including it in the House of Lords. Before that was also that was not.
Well, it did get quite a life of its own, didn't it?
It certainly did have a life of its own. Now I can't show you that's the submission that was made to the TRA. And Mr. Dingley may be able to assist in relation to that. But when one takes those the examples set out in our skeleton at paragraph 49 and the submission that's certainly made to the Upper Tribunal, there's a basis for wondering whether in fact the TRA were perhaps under slight misapprehension, if I can put it like that. Then can I we've set out the points of distinction in our skeleton between Pottiwal and also Mandip Bosic. I've taken you to Mandip Bosic already, I'm not going to take you back there. Insofar as Pottiwal is concerned, again, a completely different and distinguishable case. That is at tab 14, I think. No. Yes, 16.
That was the director's disqualification for the MTIC fraud, wasn't it?
It was. That's exactly right.
Yeah.
It's tab 16, page 74 of the authorities bundle.
Yeah.
And the director wanted to relitigate the whole shooting.
Yeah, it was the director who wanted to relitigate.
And he was found to be a privy of Red 12, namely the company. So even though he was only a witness in the first set of proceedings, he was a director and a 40% shareholder, and he was the only person who gave evidence. And so it was in that context. So there was privity of parties there, but there was not privity of parties between HMRC and the Secretary of State. And you've already been taken through the analysis, I think, that's at page 78. And we have set out in our skeleton the type of things that we say make our case different from that and make it entirely distinguishable. Now, I'm just looking to see. So, under the heading of ground 3, there was also a point made about being a proxy appeal court and relying on a decision of this court called RI, but that doesn't seem to have been pursued in all argument, and we've dealt with it in paragraph 50 of our skeleton argument, and so unless if I could just turn my back briefly. Yes, so unless there are any further questions, those are my submissions.
Thank you very much.
Thank you.
Could I just have a few moments if that's
Yes.
possible? Thank you.
Mr. Dingley, would it be more comfortable for you if we were to rise for a few minutes?
If the court doesn't mind.
Let's rise for a moment.
Can I just, sorry.
Mm.
This is that wearing case that I was
Oh, right.
referring to. I've just highlighted the part for you, which is here.
Sure, thank you.
I'll give you the rest. No. Have I got it? Sorry. It's one.
What are you citing this as authority proposition? What's the proposition?
That effectively, unless if a decision is based upon a view of the law which is subsequently expressed as being overruled by a higher court, the judgment itself remains res judicata until it and cannot be set aside.
And that goes to which point? What point is that relevant to?
The point about whether you're entitled to go behind the decision, so effectively ground 4. See, one of the arguments that you put in your skeleton is about the application of the wrong standard by the...
That was under ground 3.
Sorry, ground 3.
Yeah.
The wrong standard by virtue of the way that the TRA has assessed the evidence.
Yeah. I mean, we said two things. We said one, it doesn't seem to turn on that, but insofar as it was said, there was merit in it.
Yes.
And you're saying that it wouldn't have been wrong of the TRA to apply
That test.
because, well, why wouldn't it?
Well, at the time of that,
Yeah.
this decision hadn't yet been...
No, but the decision is only the culmination of many other decisions, including, well, anyway, thank you, of the High Court, of the Supreme Court. If you look at the history set out in Jones.
Yes, but there's no authoritative conclusion on that until it gets to the Supreme Court. In fact, you've got conflicting decisions.
What do you think? Okay.
Sorry.
That's okay. Thanks for letting me know.
Yeah. If you could, yes, of course. I'm afraid for the time. Your Lord, the court has. Sorry, I've placed before the courts
Waring.
the decision of Waring. The relevant passage is on page 227. Unfortunately, there are no paragraph numbers.
No, it's
or
too
letters.
old.
An old one.
And
I hope Miss Broadfoot has a copy of this now.
yes, she does. Yes. Oh.
Lend me yours, but briefly. Thank you. Thanks.
So the relevant part starts with Mr. Barton Butler, and it starts with the word notwithstanding until the end of the paragraph, effectively. The principle by which I derive from this case is that even if a decision is based upon a view of the law that was subsequently expressly overruled by a higher court, the judgment itself remains res judicata and cannot be set aside. Now, obviously, my learned friend, this is if, of course, you find that the TRA is in error in terms of the way that they approach the evidence. Let's say, assuming they applied the wrong standard, if you're with my learned friend on that point. My position would be, effectively, that Jones doesn't bite, because until the Supreme Court considered Jones and the authorities within Jones, there was conflicting accounts of how to approach this civil burden of proof in the context of serious allegations.
But was there? I'm not sure that's right, because I think this has been knocked on the head. I mean, I can't remember the authorities, but I think this has been up and down to the House of Lords and the Supreme Court several times. I might be wrong about that. But so your point is that...
Sorry, it has page 50, page 247 of the authorities bundle, paragraph 50, for example.
Ah, yes, read B.
Yes.
Yeah, I thought so.
And
Yeah.
before that, re-H.
Re-H. Yeah, re-N.
Yeah, I remember Lord Hoffman's judgment.
Yeah, so do I. Re-B, which was...
2009.
Yeah. Lord Lloyd Jones in Jones, at the top of page 248, although he's not requiring any sort of heightened sense of proof, does say, as a matter of common sense, proof of an improbable event may require more cogent evidence than might otherwise be required.
I think, my Lordship, there's also reference to another authority off the top of my head. That, is it the more serious the allegation, the more unlikely it is to have happened?
Yes, and that's definitely knocked on the head by Lord Lloyd Jones, very much so, in the very next paragraph. and that's Lord Carswell and Lord Brown in Reed D, following Lord Justice Richards in N. So there were contrary views that were expressed in relation to that point, which were finally put to rest by Lord Lloyd Jones in 2024.
Yes. I think that, as I said, the point that I'm trying to raise is at the point at which the TRA was deciding this case,
Yeah.
There were conflicting views about
Yes.
what the approach was.
Yes.
And therefore it's not appropriate now to go look back and say, well, they didn't get it right.
Yeah.
But that's a different point, because we're the point that is being dealt with in Waring is whether you can come back and say, oh look, the law's changed since this binding judgment was made in this case.
Yeah.
But the point we're dealing with here is a different point. It's whether the TRA directed itself correctly in law, and whether that has an impact on the weight that should be given to its decision. And that question, whether the TRA directs itself correctly in law, we decide according to the declaratory theory, i.e. the law was then, as it has been declared to be by the Supreme Court in 2024. So it's a different issue, and at the moment I'm not convinced that Waring takes us anywhere on this point. But you're welcome to persuade me otherwise.
My lady, I think I'll move on. I think that's the point that I was just trying to illustrate, but I don't see to take it much further.
It's a different point. Yeah. Your point is you can't criticise them on the basis of the fact that there's conflicting evidence. My lady says, well, yes, you can, because the evidence, because the law is then was then what it is now.
But nonetheless, that's if you can demonstrate it as they've articulated it in the first instance.
That is a more cogent point, which is that perhaps the Upper Tribunal were being a little were reading into the TRA's decision something which wasn't really there.
Yes. Again, I'll focus my submissions in respect of what was said in grounds 2 and 3, because on my view that is the strongest argument here before this court. If I could just firstly distinguish the Muin Uden case, of course that's dealing with a criminal trial, number one. Number two, he wasn't present at that trial. In this case, obviously, XYZ was present at his quote-unquote trial, and dealing with a civil jurisdiction as opposed to a criminal trial.
Sorry, which trial was he present at?
Sorry, not. I'm saying the TRA hearing, if you could.
Yeah, but that's not a trial, because the TRA isn't a court.
No, but it's a quasi-judicial body.
Well, it's not the same thing.
No, I appreciate that it's not exactly the same thing, but it's given due respect by virtue of what it says in the legislation, Schedule 3, paragraph 16 of the Act. So it's given recognition.
It's obviously given recognition, but if you're actually looking at the overall hierarchy, the TRA decision is on a parallel with the DBS decision. In terms of where it lies in the structure, and then the Upper Tribunal is the next level up, which would be the equivalent of the High Court if there was an appeal from the TRA.
I don't think that can be right, because the DBS decision is made by an administrative decision maker who is effectively part of the DBS mechanism, so it's not an independent adjudicator, which is what you find before a TRA hearing. You've got 3 independent appointed people with specialist knowledge and skills who is then supervised by a legal advisor who probably undertakes training and is usually either a barrister or solicitor of significant experience. So that's the distinction between those two.
Well, they have different procedures, but my lady's point is not to do with the procedures of the TRA and the DBS. Her point is a schematic point, which is that in the respective statutory schemes, the TRA and the DBS are at the same level, and the Upper Tribunal and the High Court are at equivalent levels in those respective schemes.
I don't think that, from my submission, I don't think that's quite right, simply because, as I said, the decision that's being made is one that's effectively being made by a person who works for that body. There's no quantification of independence in that decision.
How does that affect whereabouts it lies in the structure of the scheme?
I think the way you're being asked to look at probably is to look at the reverse. In other words, the appeal from the teachers' body goes to the High Court,
Only if it's appealed by the
Yes.
registrant. The converse is judicial review, I
Yeah.
believe.
And the other, the DBS goes to the Upper Tribunal, doesn't it?
Yes.
Which are equivalent.
Obviously, it's more restricted in the context of if one is challenging the decision from a judicial review perspective, given the limitations that are placed upon challenging any decision by way of judicial review, given the rationality and reasonableness arguments that run on both sides.
We're not saying that the schemes are the same. The point we're putting to you is that if you look at it schematically, the Upper Tribunal and the High Court are at equivalent levels in the two schemes, and the DBS and the TRA are at equivalent levels.
One could suggest that, yes. I don't know what
Right.
the point that's being made in respect to that is.
I mean, we take on
We
board.
understand the point you're making about the procedures being different and the TRA being independent, all the rest of it. We've got that.
And obviously, you can pray the fact that the TRA has the advantage of an oral hearing with all the submissions and so on and so forth, and legal advice, whereas the DBS is simply taking a decision on the papers without the benefit of all of that.
Yes. The only other point that I was going to submit in response was to do with there is obviously the possibility, given the nature of judicial review, so if the DBS were unhappy about the TRA's decision, in my submission it would be possible for them to bring a judicial review and get standing in that judicial review against the TRA's decision. Given that they're both organs of the state, they both consider the same kind of...
Well, doesn't that presuppose that they're in some way bound by the TRA's decision? Because if they're not, and they're free to attach to it such weight as they think fit, then they don't need to worry about JR. It only actually bites. Their status to bring a claim for JR would only really matter, only really be established if they're in some way bound by what's been decided by the TRA.
Yes, but I think one of the points that have been taken in the past is that, well, there's no right of appeal for the DBS. They had no interest in this decision.
Yes.
I think that, as I said, the argument to counter that is, well, you could, if you wanted to, bring a JR, and you're likely to get standing on that point.
I doubt that.
I very much doubt that.
The rules of standing are quite flexible, but I'd be quite. I mean, I would want to be persuaded by reference to some authority that the DBS would have standing to challenge a decision of the TRA. So, if you want to make that point, I think we might ask you to. We might give you some time to provide us with an authority to support that. Because at the moment, I'm an assertion that they would have standing doesn't convince me that they would.
No. The furthest I can take it before you today is effectively that the approach to standing has been significantly liberalised in the last few years, particularly around environmental litigation.
Yeah, but this isn't environmental litigation.
I do appreciate that, but the principles are the same. Effectively, they run across.
Mm.
There is a more liberal approach to judicial review in the concept of standing in that context.
Well,
I come back to the point that the DBS would have no reason to want to challenge a decision by the TRA. It wouldn't be interested in challenging it unless in some way that decision was binding on it, because if it can disagree with it, if it's free to disagree with it in the way that Miss Broadfoot submits that it is, then the decision is neither here nor there from the point of view of the DBS. It's not bound by it, the UT is not bound by it, and it affords it as little weight or as much weight as it thinks fit. Why should it then have to go and challenge it before the High Court?
Well, I think that would fall into the position you are faced with today, where you have effectively the same facts, same evidence, and they're unsatisfied with that outcome. That would be the position, effectively.
I think what the point is being made, that would only apply if we accept your argument that you're bound, as it were.
Yes. But, and the assertion that you could be bound is by virtue of the collateral attack doctrine, effectively.
Yes.
Yes, appreciate it.
In terms of how that fits together. I think that is the...
Is there anything you want to say to us about the point that's been made against you on the doctrine of collateral attack? That actually applies where somebody is actively seeking, by process of some kind or another, be it a court action or something of that nature, to challenge the underlying decision, the previous decision. Whereas in this case, nobody's actively seeking to challenge the decision of the upper tribunal. They've simply disagreed with it. Sorry, the TRA. They've simply disagreed with it.
Sorry, just...
There's no process. Well, in all of the cases we've seen from Hunter onwards, the doctrine of collateral attack has been applied in circumstances where X is not happy with the decision of a previous court and has sought to go behind that decision by bringing some kind of process or procedure in which the same issue arises and they want to get a different conclusion. And that is not the parallel with this situation, because nobody is initiating any form of process to challenge the TRA decision. What is happening is that the upper tribunal, more or less of its own motion as part of its function, has said, we're not bound by this, we'll give it such weight as we think fit, but we're going to examine it, and we are free to come to a different conclusion. And therefore that's not really what the collateral attack doctrine is designed to prevent. That, I think, is the meat of the argument against you. I just wondered if there was anything you wanted to say to us further in relation to that.
Yes, so if I think it's cited in my skeleton, my learned friend who acted for the DBS on that occasion in the upper tribunal effectively requested that the upper tribunal go behind that decision on the factual merits. So that's the point that's distinct.
Right.
In this case, had he not asked them to do that, I think we'd be in a different category. But I think that specific request is the point.
Right. That's helpful.
And quote unquote, it is not an abusive process. So
yeah.
Specifically taking that line of argument.
Yeah.
The only other point that I was just going to say, it may be of interest or it may not, but the concept of a cause of action is just simply a set of facts as opposed to an appeal or a claim being filed. So if we're talking about a cause of action estoppel, my submission is that it just simply requires a repetition of the facts as opposed to a process where one files a claim form or indeed an appeal of some kind. But
the cause of action is not the same thing as a process, but it's not the facts either. The cause of action is what you have to show, or it's the ingredients that go together in order to give you the right to make a claim for something.
So for example, I mean, you could have the same facts could give rise to a cause of action for breach of contract and a cause of action for negligence. But they're two distinct causes of action.
Yes, however, in this case, as my learned friend outlined to you, the facts here was the referral of the head teacher on the same facts to two bodies. So that's
not a cause of action.
Sorry.
It's the same set of facts, of course, and a cause of action is defined as a set of facts.
By whom?
Who defines it as a
Who
set of
defined
facts?
it as a set of facts? Where do you get that proposition from? Because it's a novel one to me.
I do have an authority that I wasn't able to print off during the period, but I have found one that is relevant, that does specify exactly what a cause of action is.
Well, it just says it's a set of facts floating in the ether.
No. What it says is the name of a cause of action is used to identify a cause of action is used as a convenient and succinct description of a particular category of a factual situation, which entitles one person to obtain from the court a remedy against another person.
I don't see any difficulty with that.
No.
As a proposition.
But I see how it helps you, because it's not just the facts, it's the legal description that you give the facts in order to get the remedy.
It's the consequence of putting those together is that you have a right of action.
So if you, on a set of facts, if you make a claim for breach of contract, you can get a remedy for breach of contract, but you cannot get a remedy for negligence, even though the same facts might give rise to a claim for negligence, unless you make a claim in tort as well.
Yeah.
I'm sorry, I'm just really struggling with the idea that it's just
I
a
think
set
I'll
of facts.
conclude my submissions on that point, unless there's anything further I can assist you with.
Can I just have two further things? One, I just wondered if there's anything you wanted to say about the point that's obviously being made against you, that the two bodies have two very different aims and considerations, albeit of the same individual and on the same set of facts, and the significance of that.
The two bodies do have, I think the uniqueness of this case is it's basically tasked with looking at the same facts again, and it makes alternative findings.
But do you accept that they are two, well, not only two separate bodies,
I think
obviously
what I
are,
said
but
to my ladyship earlier was that had the Upper Tribunal said, well, actually, these two lifts on their own are sufficient to bar him, we'll leave it at that, that would have been fine. But the way in which they've gone through the decision is problematic, because they haven't done that. They've predicated their assessment on these other factors which contribute to the overall assessment of his credibility and so on and so forth, and sexual motivation, rather than saying, on its own, these lifts would have been a problem.
I see. So, in other words, if they'd accepted precisely the same set of facts but weighted them differently, in the sense for their purposes,
Yes.
you wouldn't have had a complaint.
I think also the fact is that the TRA has made specific findings about there being no evidence of, the messages and so on. But these are all important factors that weren't necessarily weighted properly within that decision. They are obviously different bodies tasked with different things, but they do cross over, which makes this slightly more complicated in the sense that what is the remit that it has in terms of.
But you accept the basic point, they are looking at two different areas, albeit they may have similar consequences.
Yes, I'm not going to make a concession to say that they're not privies, because I think I have to put that at the highest, because it really supports what we're trying to say about collateral attack and all the authorities that go with that. But if you're not with us on that point, I think, yes, I have to accept that. But then looking at how the decision was made is perhaps the key distinction here.
And the only other point, is there anything you want to say, Jan, or do you accept that there was here, it doesn't appear to have been taken, a right or review of the DBS decision, looking at paragraph 18A?
Yes, I think what my ladyship also was directed to is that or mentioned effectively, is the onus is on the DBS effectively to conduct the review.
Yes, of course.
And if you look at the terms, as I said, if we just imagine a usual situation where.
Well, what about this situation?
I think it's important to just contextualise that the decision that the person receives says you can review this in 2030.
Yeah.
It doesn't say you could ask us at any time, which is what my learned friend said on her instructions they would be able to do. So a person receiving that must think that that is the case. I can't.
But in this case, you had lawyers and so forth.
Yes, correct. But again, the onus is on the DBS to get that review. It doesn't invite you to make a request to review that decision. It just says you have to wait until 2030. So taken on the face of it, that's what it says.
Yes. But isn't entitled to say, well, that if you actually have a look, you can see that there is an ability to review, and obviously it's something you could have raised with the
Again,
DBS.
it's not expressly set out, nor is there a policy that's been put before you.
But I thought you told us that there were financial constraints and all sorts of other considerations that went into a decision not to go for a review, but rather to pursue the appeal.
Yes, that is the case, but in terms of that review process, I wasn't aware that you could effectively review it. At
No.
that point.
But
But any event, dealing with it now,
Yes.
my point would be that it doesn't necessarily invite you to do so. There's no policy anywhere that says you can make the representation.
Now, on the face of it, it's a little confusing. You can very fairly say that until Miss Broadfoot on instructions told us that there is this practice of writing in and saying, well, will you exercise your power, DBS, to have another think in the light of the further information that's come forward, then somebody would be forgiven for thinking they couldn't do anything until 2030.
Yes, and that was certainly the position. Unless I can assist the court further.
Right. Well, thank you both. Thank you all very much. I haven't forgotten Miss McLaughlin. Thank you very much for your submissions. We'll obviously reserve our judgments. Having discussed this matter with my lord and my lady, we do think that it might be of some help to us if the parties could see what they can find in terms of the extent to which issue estoppel principles apply in the public law context, just so that we get a steer. We don't want to be deluged with authorities, please, just something very brief. But if we could give you, should we say 7 days to produce something in writing that you think might be of assistance, or if you can't find anything, just let us know that you can't find anything. But just because we are not dealing with the standard situation in which issues of that nature arise, and the only case we've been shown that even sort of trespasses on this field is Mr. Justice Mostyn's decision, which does have its own peculiar factors that one puts into it. I think in terms of the principles, we might be assisted by something further if that's not putting too much on both the parties.
Specifically issue estoppel, because of course the case was put on
Yes.
the basis of cause of action.
Yes, it's really the abuse of process point. So that is allied with issue estoppel. It's the not being vexed twice for the same cause, really, but in that context. I mean, don't worry about cause of action estoppel, because there is no such thing.
There's no such concept.
There's no such concept in public law. Yeah. Thank you. So is 7 days going to be enough?
Yes.
Well, we will obviously reserve our judgments, and we'll wait until we've had the further submissions from you. We'll let you know when we're ready to hand them down. All the usual rules will apply. You've got experienced counsel here, don't need to be given a lecture about confidentiality, but the normal rule is that obviously when the draft is disseminated, it's for the purposes of correcting typing errors and obvious errors of that nature, not the purpose of re-arguing the whole case. And obviously clients can be shown it under the same strict points in relation to privacy, with the usual dire warnings attached, but we leave that to the parties' solicitors. I know, Mr. Dingley, you and Mr. McLaughlin are acting on direct access, so there's a degree of a burden on you that would otherwise fall on instructing solicitors, but we're sure you'll be competent and professional about explaining to XYZ that he can't, what he can and can't do with the draft until the official hand down of the judgment. Thank you all very much indeed.